event. Hi, everyone. Thanks for attending an inside look at recall elections. My name is Carmen Beery. As indicated in the materials for this particular presentation, I'm a partner here at Murray, Dahl, Beery, and Renault. To address Mike's good question again as an initial matter, if any of you do wish to ask questions or pose scenarios, and talk a little bit within the confines of this particular Zoom call about anybody in particular in your organization. First of all, you may choose to do that. That's within your discretion. Is this a sunshine law, open meeting law, public meeting of any of your individual entities or bodies? No, in my opinion. There are certainly more than 3 or more, or whatever a quorum may be, of your particular BOCC. There's certainly more of you here than that, but from a particular agency, we at least didn't convene this meeting for purposes of conducting public business for any of you, right? This is very much like any other sort of event that maybe more than one of you showed up at and are receiving information. So your entity may have noticed it out of an excess of caution. Just another aside, let's say one of my municipalities told me that a couple or more of our city councilors were going to attend some sort of a training. I would probably have advised the clerk to notice it out of an excess of caution. And if any of you have done that and have follow-up in regards to the implications of that, I'm happy to give you my thoughts on that. I'm sure your county attorney is happy to give you their thoughts on that as well. But in terms of this being open to the public, it is not. It was invitation only. You all had to register. There, to my knowledge, Leslie, correct me if I'm wrong, there's no ability for anybody like the press to either attend this or to obtain a copy of this under CORA, in my opinion.
Well, it is searchable online, but it's highly, it was not advertised to anybody like that. So it's unlikely that we would have any journalists here.
Could someone attend this without registering, Leslie?
No, they would not have gotten the link.
Okay. So hopefully, Mike, that answers the question.
So what I'm hearing is that this is a safe space for us to express if we have specific questions as it may pertain to today's topic. And shall I get started with my quick introduction and then turn it over?
That would be great. That'd
Excellent.
be great.
Okay, good afternoon, everyone. I'm Mike Bordonia, the San Miguel County Manager, and I'm also the new president of ACCA, the Association of Colorado County Administrators and Managers. And I'm here with our staff, Leslie Shivers, and our new staff, Carrie Ortiz. As a part of our ongoing educational offerings from ACCA, we heard from many administrators from around the state about their questions and challenges pertaining to the turnover and specifically recalls of elected officials. Today, we hope to provide information and a resource for you to help navigate these challenging waters. Our guest speaker today is Carmen Beery, partner at Murray, Dahl, Beery, and Renault, LLP, located in Lakewood, Colorado. Ms. Beery's practice is focused on local government representation since her admission to the bar in 2000. She has served as the city or town attorney to several Colorado municipalities, as well as private entities and individuals with state and local government issues. Ms. Beery advises clients on local government and municipal specific issues such as zoning and land use law, sales and use tax matters, and TABOR. We are honored to have her with us today. And at this point, I'd love to turn it over to you, Carmen, and thank you very much.
Absolutely. Thank you, Mike, for that lovely introduction, and welcome, everyone. I do have a presentation, a PowerPoint presentation to share with you today. In a second, I will attempt to successfully share my screen so that you can all see that. Before I do, I'll give you a little bit more information on top of what Mike shared with you about who I am, and what sort of experience I bring to you today. As Mike mentioned, our firm and myself specifically focus on the representation of local government entities. That does my practice and that of most of my colleagues does focus on municipalities. I want to be very transparent about that. For 25 years, I've represented, for the most part, cities and towns. I've done a little bit of work for counties, typically as special counsel for certain particular special projects or for sort of one-off projects. And so I am familiar in some respects with counties. How they operate is certainly very similar to how municipalities operate, particularly statutory municipalities. Like counties, we are very much statutory municipalities driven by state statute. Home rule cities are a little different, but we don't need to even go down that rabbit hole. I am familiar with the recall process as a result of, I don't know, luck or bad luck, good or either. In my experience, I was reflecting on this last night. I have assisted clients through about 6 or 7 recall processes throughout my, again, roughly 25 years of experience. So on average, it's not quite every other year. It's maybe every 3 years or so. Again, on average, I've helped clients, municipal clients primarily, navigate the recall election process. The processes are, and we'll talk a little bit about this as we go on, are relatively similar in terms of the county process and the municipal process. However, there are some differences. I will mention those and flag those when I see those as we, again, talk further about the process. And you may hear me through the course of this afternoon let you know that this is a county-specific process that I'm advising you to get really specific advice from your own county attorney, maybe on a particular aspect of how nomination petitions are circulated in counties versus municipalities. The nitty-gritty of some of the statutory operations are a bit different for cities versus counties, but I'll do my best to let you know that. And don't want to pretend to be a county attorney because I am not. You each have, I'm sure, very good legal counsel who you can also consult with on these matters as well. But in terms of recall, again, for good or bad, I have some sort of weird attraction to being experienced with these things. So last thing I will add before I share my screen, I see something in the chat here. Throughout the presentation today, we were talking a little bit before we began. It's certainly okay with me if any of you have questions as I'm going through things to do the virtual hand raise or wave feature here on Zoom to catch our attention. Leslie and Carrie and Mike have collectively, well, Leslie and Carrie, Mike volunteered Leslie and Carrie to keep an eye out for you raising your hand or waving at me to ask a question. If, again, one occurs to you as I'm going through things, please feel free to interject in that way so that you don't forget it. I'm happy to, at a stopping point, address questions as we go. So with that, here comes the big screen share. Okay, let me go to slideshow. All right. So an inside look at recall elections. What I wanted to begin with are legal aspects and logistics. I want to cover with you folks today 3 main categories. The first is the biggest, which is, as mentioned, legal aspects and logistics. That, for me, means looking at the statutory provisions and really the practical basics of how the recall election is run in terms of the true process, nuts and bolts, from the beginning of notice from a citizen of, hey, I would like to initiate a recall process. How do I do that? To an inquiry probably made to your clerk and recorder's office, to the actual conduct of the election, or at least the precipice of that and getting the ballots ready. We'll go through all those legal and logistic aspects. It's certainly not expected as administrators that you are hands-on, as it were, running the election and these real nitty-gritty details of the process. However, I do find it useful for you to know, and sort of on the parallel, sort of my city managers or my city administrators, I find it useful, and I think they find it useful to know what the real practical process is, so they understand the machinery of all this and what their staff are dealing with as this recall process trundles on. So that's why we're going to cover these legal and logistic aspects. For all kinds of elective officers in the state of Colorado, the recall authority and process is generally governed at a big picture level by the state constitution, specifically Article 21 of the Colorado Constitution, which provides that every elective public officer in the state may be recalled from office by the registered electors entitled to vote for a successor. All that means is essentially, right, the folks entitled to and registered to vote for a certain office can recall an officer from that office. I, not being a resident of Pueblo County, for example, am not entitled constitutionally to attempt to recall an officer in Pueblo County. It has to be an elector entitled to vote for that particular office, right? Which I think makes entirely intuitive sense. Recall is initiated by the circulation of a recall petition. Signatures on the petition must equal 25% of the entire vote cast at the preceding election for all candidates for the incumbent's position. And we'll talk a little bit about that more in a second. An elected official cannot be recalled, generally speaking, until they have held office for at least 6 months. There is, you see parenthetically, a note that there's an exception for state legislators, which I don't know why the framers of the Colorado Constitution did not favor state legislators, but they get a whopping 5 days in office before they are subject to recall. Our folks at the municipal and county level, our elected folks, have what you would call, right, a grace period to sort of get acclimated and hold office, and I think demonstrate to the electorate what they're about, how they will do things, how they will perform in office before the electors have the right constitutionally to file a recall petition. So we have that 6-month grace period. The Constitution also includes provisions for the form of the petition, when a recall election shall be held, and how to fill a vacancy if the officer is indeed recalled. The Constitution further gives counties and municipalities, both local jurisdictions, the authority to provide for the manner of exercising recall outside of the constitutional provisions, even to the extent that those provisions are different than what the Constitution says. The Constitution, sort of like home rule, right? It allows counties and cities to alter some of these recall features, with the exception of this 25% signature threshold. Local jurisdictions cannot increase, cannot require more than 25% of the signature threshold to initiate or to achieve a recall petition election. So these are the constitutional provisions that govern, again, all state elective officers, including local ones, unless altered, right, by local provision or altered by state statute, or I should say supplemented by state statute. In addition to the Colorado Constitution, the Colorado revised statutes further provide recall processes and recall election and process details. For counties, those statutory provisions reside under Title I. Title I of the CRS, which is Colorado Revised Statutes, specifically Article 12, sets forth the recall process that governs county officer recall. Title I of the CRS, specifically the first part of Title I, Articles 1 to 13, are the Uniform Election Code. I imagine your county clerks and recorders are very familiar with the Uniform Election Code. That is the set of statutes that govern county and state election processes. For a lot of my clients, municipalities, this election process, if it's not coordinated with the county, is governed by another part of the CRS, Title 31, That's the title of the statutes that govern cities and towns generally. And there are municipal election code provisions in there that govern recall for those particular entities. But for you folks, again, we're looking at Title I. So what does Title I, Article 12 say about recall elections? Signature requirements. Again, we see this language: a petition shall be signed by electors in number to 25% of the entire vote cast at the last preceding general election for all candidates for the office which the incumbent sought to be recalled occupies. The statute goes on to say that if more than one person was elected to fill that office to which the person sought to be recalled as an incumbent, then the petition shall be signed by eligible electors entitled to vote for a successor, equal in number to 25% of the entire vote cast at the last preceding election for all candidates for the office to which the incumbent sought to be recalled was elected, the entire vote being divided, long sentence, the entire vote being divided by the number of all officers elected to the office at the last election. Again, huge, ridiculous sentence that only an attorney could write or love. But what does all of that mean? Let's talk about that practically speaking. At a very basic level, let's begin with an officer who holds a singularly unique office that no one else holds, such as, let's say, sheriff. If a sheriff, I'm going to use very simple numbers to make the math very simple and hopefully make illustrative sense. If a sheriff, for example, is the subject of a recall, and we're trying to figure out the number of signatures that would be required to actually get a recall election mandated, we would look at the last preceding election at which a sheriff was elected. And let's say there were in total 100, again, ridiculous, I know, but just for illustrative purposes, there were 100 votes cast at the last regular municipal election for the office of sheriff. Let's say our particular sheriff was elected by a yes vote of 65 and a no vote of 35 of those 100 votes. So our sheriff took office at the last election. But then someone wants to initiate a recall petition. What the language here in the statutes and the Constitution requires in terms of number of signatures on a recall petition is 25% of 100 votes, okay? 25% of all the votes cast at the last preceding election for that particular office. So not 25% of the people who said, yes, let's vote this person, right? Not 25% of 65, but 25% of 100. What this second paragraph addresses are offices like Board of County Commissioner or other offices that are not singular and unique to one person or one office. So let's look at an example in that realm. Let's say in the last preceding particular county election, there were 2 county commissioners elected. And to make it very, very simple, because this can get really, really detailed and very specific to specific situations. But let's keep it simple and say that there were 2 commissioners elected at large, okay, throughout the whole county. And at the last preceding election, for the 2 at-large seats that were elected at that election, there were 400 total votes cast. Again, yes or no, and for both of those elective offices, 400 total votes cast. If someone then wants to initiate a recall election and file a recall petition and gather signatures against one of those county commissioners, what we would do to get the signature threshold or the signature threshold to mandate a recall election is to look at all the votes cast for all of those commissioner offices elected, which is 400 votes cast. And we would divide that 400 votes cast for all the offices by how many offices were actually elected, right? Which is, of course, in our example, 2. So 400 divided by 2 is 200. And then this last paragraph you see here on the screen requires that 200 number be the number that we use to apply 25% to derive our signature threshold for a recall petition for one of those county commissioners, which would of course be 25% of 250 signatures would be the number. I think the goal of this second paragraph and how the Constitution and statutes direct us to do the math on signatures for, let's call it multi-seat offices. I think the goal is very much to find the average of how many votes were cast for that particular seat, right? Because we don't have that sort of singularity that we have with, say, the treasurer or the coroner or the sheriff, with one person being elected. So I think the goal of the statutory language is let's average out how many people probably voted for each seat and then apply 25% to that particular number. So I think that's the goal. All right, what else do the statutes say in terms of the recall petition? It goes on to address petition requirements. No petition may be circulated until the form of the petition is approved by the county clerk and county clerk and recorder. The form of petition, again, that is the form that is blanked, no signatures on it, but much like initiative or referendum, oftentimes the law requires before registered electors exercise their right to redress or petition their government, the form of that has to be approved very often by the clerk's office, whether that be municipal or county. That form is called, again, under the statute, the printer's proof. So no petition may be circulated until the first printer's proof is approved by the county clerk and recorder. The petition itself and the form must designate by name and address a committee of up to 3 people to represent the signers of the petition. The petition shall contain the name of only one person sought to be recalled. I hope that you are not in the position that you have more than one recall election or recall effort going at one time. It does happen. We have seen it happen. Again, not a fun process, and it's it can get even more complicated when you're doing the math for signatures and calculating timeframes for multiple recall petitions that are being pursued at once. But should you have that situation, know that one petition can only contain the name of one person. I did actually have in one instance, a proponent of a recall, a citizen, come in and want to inquire about filing a petition for like the entire council. Like, I want to recall everybody. And while that might sort of seem to the citizenry like a valid option, when you think about it, it's while maybe convenient for that person who would like to pursue that, it would present the problem, I think, at the eventual election, right? In that voters could not pick and choose. Well, I would like to recall this person, but not that person. That would be very much akin, allowing someone to pursue that would be very much akin to having, elections for groups at a time. Oh, this is my city council. I can pick this city council or that city council, or this BOCC, Board of County Commissioners, or this one. And we just don't do that, right? We give folks, electors, the right to vote on individual people and individual ballot questions and individual issues, single subject, at once, at one at a time. So a petition can only contain the name of one person sought to be recalled. The petition must include an up to 200-word statement of the grounds on which the recall is sought. The petition may contain, and I'll address this a little more later, it may contain an up to 300-word statement from the incumbent, the person sought to be recalled, justifying their course of conduct. That's the language of the statute. The petition must contain an estimate of costs to conduct the recall election. That estimate, that cost estimate, will be provided by the county clerk and recorder. I love this particular statutory provision because we don't have this in the municipal recall election statutes. And I think it's an incredibly valuable piece of information for potential signers of the petition to have. It's a quite common question from the governing body to staff, to true citizens at public comment who come into meeting, like, how much is this going to cost? What's the cost of a recall election? And again, in the municipal context, there is no mandate that that information proactively be pushed out to electors and to potential signers of the petition. You in the county context have this as a mandate on the actual petition that will be taken out. So anybody thinking about this, wondering, should I sign, can factor in to their willingness to sign the petition or not, the true cost to taxpayers. So I think that's a great provision in the county statutes. The signature pages are also obviously provided on a petition form, having lines for everybody to sign and indicate their residential address, the date of signing. And at the very end of each petition section is an affidavit of the circulator. And that's the person who literally circulates, carries around the petition to gather signatures. Moving on to other requirements of the petition, I said I would mention a little bit more about the statements that are to be included on the petition. Again, mandatory is the recall committee statement here, this first bullet point. And again, the petitions, as we recall, up to 3 people must be designated to represent, to be what we call the recall committee, to represent the proponents of the recall. That committee, that group of up to 3 people must put together a statement, must come up with a justification to this recall effort. And again, it's maxed at 200 words. And it must state the ground or grounds on which the recall is sought. And this statement shall not include any profane or false statements. That's an interesting point as a lawyer, but I'll gloss over that. The statement is for the information of the electors, who are the sole and exclusive judges of the legality, reasonableness, and sufficiency of the ground or grounds, and the ground or grounds of recall are not open to review. I've underlined here, that's my addition, not emphasis provided, not in statute. What's critical, I think, here from a legal perspective is that the proponents of a recall are really unbounded and unrestricted in their motivation, in their proposed grounds for recall, in their justification for why they think a particular elected official should be removed from that elected office. There is no judicial review of the reason, other than this whole no profanity or false statement issue, which again, the statutes don't say who's checking that. So other than that sort of general admonition to the committee members, whatever reason they come up with, whatever grounds they articulate, is not subject to review or judgment by anybody but the electors. And one might think that's good or bad. I'm not here to judge the good or bad of that, but I do note that that is, I think, consistent with the electoral process, generally speaking, the qualifications of someone to serve in office, if that someone meets the requirements otherwise provided for the office. They're a resident of whatever the jurisdiction, they're of a certain age, if age is a requirement, as it typically is. If someone meets those general requirements of being eligible to hold office, well, the electors, everything beyond those very sort of general qualifying characteristics, someone's suitability to serve in office is completely up to the voters. And recall carries that, I think, idea through to the recall process. So the recall committee has up to 200 words to state their case. And then the incumbent also has an opportunity. Fair is fair, right? The statutes provide that the officer sought to be recalled may submit to the designated election official a statement of 300 words or more. They get a few more, right? They get a few more words and time and space to justify and provide a defense, if it were, to justify their course of conduct. The officer also, like the recall committee, is required by statute not to include any profanity or false statements in their own statement. And their statement, the incumbent officer's statement, should they choose to provide it, is included on the petition, on the form of petition, if the incumbent provides it to the clerk and recorder within 3 business days of their receipt of the first printer's proof, of the first proposed form of petition that's given to the clerk and recorder. If the incumbent does not choose to, does not find the time to, does not care to, whatever, if the incumbent does not provide that justification, that sort of defensive statement before the form of petition is approved, that is not the incumbent's last chance to do that. And we'll address the next chance in a minute. But the incumbent doesn't have to provide that kind of a statement, and certainly doesn't have to provide it at this point in the process when the form of petition is being finalized. Other details on the petition: the form of the petition must be approved or disapproved by the close of the 7th day following submission of the first cut of what the petition shall look like. If the clerk and recorder disapproves the form of petition, he or she or they are directed to give the specific reasons for the disapproval, and the recall committee can take another stab at it. They can correct any directed specific reasons for rejection of the form of petition and file it again with the clerk and recorder. And the statutes say that would be filed and reviewed just like the original, right? So we sort of do that process over and over if the recall committee wishes to continue to try to fix any sort of deficiencies in the form of the petition. Again, we're just talking about the form. The petitioners must circulate and return the approved petition with signatures. So let's say the form is approved. Now we're into signature gathering. The petitioners have generally 60 days following the date on which the petition was approved as to form. Petitioners can, and by petitioners, I just mean the recall committee, whoever's out there circulating on behalf of the recall committee. It's very much the committee, those designated people who will likely be turning the petition in. And they may do so at any time within the 60-day period. They could take 59 or 60 of those 60 days. They could take 30 days. They could take 5. What is important, though, and impactful is that there is one opportunity to turn the petition in. Again, in a lot of contexts, initiative, recall, a referendum, petitions are not just one big document, but a form that's approved that gets copied, and there are several sections that all look the same, and several people are out there circulating. So there may be 25 or 30 or 50 petition sections that are being out there. The recall committee is directed by statutes to gather all those sections together and submit all those petition sections together one time. The impact if they don't do that is that the first batch or the first petition sections that are filed are the only ones that count. So your clerk and recorder should know, and I'm sure we'll consult with your county attorney if this comes up, if petition sections sort of dribble in, or someone says, we found some and we forgot that we had these, or they were, I actually literally heard this before. I found this one under the seat of my car, like a couple of days. Can I still turn this one in? And the answer would be no. Upon receiving signed petitions, the clerk and recorder promptly reviews the signatures and verifies them against voter registration records. Signatures that are unverifiable as compared to voter registration records can be cured as provided by statute. This is an opportunity here where I will say the cure period for curing unverifiable signatures under the county election statutes is a bit different under municipal statutes, but it's that same process that, again, I advise you, if you're ever in that situation, wanting to know how that process runs, to consult your county attorney. After reviewing and potentially going through the cure process for any kind of deficient signatures, and not later than 20 days after the signed petition is filed, so generally speaking, a month, not quite a month unless we're in February, right? 28 days after the signed petition is filed, the clerk and recorder notifies the recall committee and the officer, the incumbent officer, of the number of valid signatures that were provided and whether or not the petition appears to be sufficient or insufficient. What does the county clerk and recorder do next in either case? In the case of an insufficient petition, the county clerk and recorder is required by statute to provide, again, the specific reasons, just like when she or he or they were looking at the form of a petition, right? Now that they're signatures, county clerk and recorder must again provide the specific reasons to the recall committee. Fortunately, that can be done by email to sort of keep things moving. And the determination of an insufficient petition can be appealed to district court within 5 days. The recall committee, those designated people who are designated to represent the recall petition on all matters, they are the only people with standing to appeal to the district court. That means they're the only people who have the legal right to appeal. Why doesn't the incumbent have the right to appeal? Well, because it's insufficient, right? The incumbent isn't harmed by anything in the case of an insufficient petition. The recall committee members potentially, and the recall effort that they are representing, they have potential injury, so they have standing to appeal. That would be certainly an expedited review. And I'll touch upon this too later. Generally, anything within this recall process that is subject to judicial review, we have the benefit of having the courts directed to expedite any sort of process that requires judicial review so that, again, the recall timeframe can generally keep going as it's required to under statute. What happens if a petition is sufficient? There are enough signatures that were verified on it. Then, in that event, a protest may be filed by an eligible elector, within 15 days after the petition is deemed to be sufficient. And the elector must list the grounds of a protest. What would be the grounds for a protest of a sufficient petition? The statutes tell us that the grounds are limited to two very specific things. One, the failure of any part of the petition or the circulator affidavit to meet the requirements of the statute, the technical requirements, or two, any conduct on the part of the petition circulators that substantially misleads people signing the petition. Two particular grounds for, let's say you have an elector who is seeing this go on, and their neighbors and people they know circulate a petition for someone who they think is doing a fantastic job, and they think the whole recall effort is bunk. Can they protest this recall effort in this fashion? Of course, they can protest and use their vote to vote no on it, but do they have legal recourse under the statutes to try to stop a recall effort? Yes, but it is limited to these two very distinct legal grounds. Really, whether the form of petition is somehow deficient or the people taking around the petitions to gather signatures misled people, maybe told people it was for someone that it's not. If someone, an elector, feels they have credible evidence of either one of those grounds, then yes, then they would have the ability to file a protest and potentially win that protest if they were able to prove misconduct on the part of the circulators or a failure of the petition to conform to the required form. Who holds this hearing? Who decides this protest? The county clerk and recorder can do it themselves, or they are authorized to appoint a hearing officer by statute. I strongly suggest, and I bet your clerk and recorder would too, appointing a hearing officer if you have the ability and the budget to do that. Why? Because obviously, right, it removes your clerk and recorder from this potentially really divisive political process, which is an advantage to them. It also, if the alleged grounds of the protest are, hey, this part of the petition isn't as to form how it says in the statutes it should be, well, it will be somewhat awkward for your clerk and recorder to be hearing a protest on the form of a petition that the clerk and recorder themselves approved, right? Because remember, they're the person who approves the form of petition in the first place. So for a few different reasons, all of which I think are good, appointing a hearing officer in this context, I think, is a very good move. Again, if you have the ability and the budget and the flexibility to be able to do that. Cognizant of time here, moving right along to recall timeframes. After the protest period expires, or if you have a protest filed, after that protest is concluded, then what? Okay, so protest disposed of, and let's say it was unsuccessful, and the recall effort, again, because we have a sufficient petition, the recall election is allowed, the effort is allowed to proceed. What next? The county clerk and recorder under the statute is directed to wait 5 days to see if the incumbent resigns. I put the statutory language on this slide because I thought it was remarkable. One, in terms of the pressure that it puts on the incumbent, but two, for the plain language of the statutory language, or this statutory section. Very rarely do we see statutory language that is kind of this, wait 5 days to see if they resign. It's a very plain and direct statement that, again, puts the onus on the incumbent, the subject of the recall, to make a decision. Gosh darn it. I think at this point, it's worth noting, and I'll talk a little bit more about this in a few minutes. Haven't touched upon this a lot yet because I'm talking a lot about the logistics and how these things work mechanically. But I think it's important to recognize and keep in mind the human aspects of this recall process, which is very real. Not only from the people who are very passionate that this person should not be in office anymore, but the emotions of the person who is subject to recall. I've seen firsthand, and I'll share a little bit more later, the toll that can take on the people, the individuals who occupy these offices, who are all of a sudden being sort of publicly called out and named as not doing a very good job and the subject of displeasure. And here we see, again, sort of that sort of aspect of this. The incumbent who is named is the onus is on them, all eyes on them, so to speak, to see if they choose to resign or not in 5 days. If the incumbent does not choose to resign, then on the 6th day, the clerk and recorder is directed to create a certificate of sufficiency of the recall petition that's signed. Hey, enough signatures, and the incumbent did not resign. So now a certificate of sufficiency is created by the clerk and recorder and posted on the official website of the clerk and recorder by noon on that 6th day, on that day after, if no resignation has occurred. Here, I will note, is that aforementioned second chance of the incumbent to file their own 300-word statement if they didn't do it before, when the form of petition was being set. The incumbent has here again a chance to file their own statement of, hey, here's why I should not be recalled. And they have 10 days after this certificate of sufficiency is issued and posted by the clerk or recorder. Within 24 hours of posting that certificate of sufficiency, the clerk and recorder shall call the election and set the election date not less than 30 nor more than 60 days from the date of the certificate. So we're 1 to 2 months out from the certificate of sufficiency when we must have a recall election. However, the statutes tell us that if a general election is to be held within 120 days, or roughly 4 months, of the certificate of sufficiency, then in that event, if we're that close to a regular election anyway, we're directed to wait and make the recall question part of the general election. Notwithstanding that, the statute further provides that a county recall election cannot be held within 60 days after the date of a primary general or congressional vacancy election. So what can we sort of divine from this? From 120 days before a general November election to 60 days after the general November election. That's a time period, a window, a recall election free zone, let's call that, where your county clerk and recorder won't be burdened with conducting yet another election within that proximity to an election they're required to conduct anyway to decide other issues. As noted, leading up to the election, the Incumbent is kept apprised of certain things happening throughout this process. They receive notice of the form, a petition being approved and other things. And throughout the process, the incumbent gets specifically notice of the first printer's proof of the proposed form. They get notice, the incumbent, on the day, the very day, the statute says that the clerk and recorder, the day that the clerk and recorder approves the recall petition form, the incumbent gets notice of that development. So they know that, hey, signature gathering is about to happen in my community about me. The incumbent gets notice within 24 hours after the signed petition is returned to the clerk and recorder's office. And then, just as mentioned, I didn't put this on here, but we just addressed it, when the clerk and recorder determines the sufficiency of the signed petition, the incumbent gets notice of that as well. Throughout the process, the person who is subject to this is given updates, significant updates of significant, I should say, updates of significant events or steps forward in the process. The incumbent is notified so that they're not in the dark about this particular effort that's particular to them. Concerning the election and moving forward to the election itself, the election could be canceled if the incumbent resigns prior to the nomination petition deadline. And what that means, the nomination petition deadline, is the deadline for candidates who wish to be nominated to fill a vacancy in office if the recall is successful. Just like now, right, most of my clients are going through the election process for this November, and the nomination petition deadline was this past Monday for folks to, again, not because of recall, but file their petition to be nominated to fill an office. And in this circumstance, we're talking about the nomination petition that may be circulated by interested people who have heard that a recall election, right, because we know that that date's been set now. Folks may circulate nomination petitions and seek to fill the vacancy in the event the recall is successful. So the election can be canceled if the incumbent resigns. Remember, we had that 5-day pressure-filled, are they going to resign or not, before the election date was set. Well, now the incumbent could still change their mind and resign, but they have up until prior to the nomination petition deadline to resign and cancel the election. If it's a coordinated election, right? Because remember, the statutes direct us that if we're within that 120 days before an election, it's going to be part of the coordinated election. 5 days prior to the date to certify the ballot content is the deadline to cancel a recall election in that circumstance. As one might expect, the outcome is a majority. If a majority of the electors voting on the question vote yes to recall, then the incumbent is removed after the qualification of a successor. If a majority vote no, the incumbent remains in office. A tie vote results in the incumbent remaining in office as well. That is not construed as a expression that that person, that the will of the community is that person be removed. Other recall, a few other, I think, sort of nits and nats and recall matters I wanted to address before we move on from logistics and sort of mechanics are that the successor candidates, again, as mentioned, are nominated by petition in sort of the usual fashion under statutes. The officer subject to recall, this might be obvious, maybe not, but the officer subject to recall may not appear on the ballot as a potential successor candidate. So shenanigans can't be played there. You couldn't simultaneously be subject to recall and then be nominated to fill your vacancy if indeed you are recalled. And finally, no recall petition may be circulated or filed until an officer has held office for up to 6 months. Remember, we saw that language in the Constitution, or against an officer who is up for re-election in 6 months. I recently had experience with this latest issue. An officer whose term is about to expire in November, a citizen in about late July, inquired to the clerk's office, hey, I'm interested in filing a recall petition against Officer X. And at that time, right, the clerk and I looked at the term sheet and when this officer's term was up. This officer's term was up this November. Was that officer eligible to run again? Yes. Did we strongly suspect that officer would run again? Yes. I think the citizen strongly suspected that officer would run again, but we did not know. And even if we did know by some expression from that person at that time, we were within 6 months of that person's term, that term being over. So it was irrelevant and is irrelevant if that person ran again, which they did. By the way, they filed a nomination petition to run again. But even if it's at the end of a potential reelective term and that person may indeed be reelected, that particular term is, if that particular term is up within 6 months, that official is not eligible to be recalled. So I found that to be an interesting little wrinkle. Moving on from a lot of these sort of logistic and legal issues into roles and responsibilities. Again, I'm cognizant of the time. And Leslie, Carrie, feel free to interrupt me if there are burning questions out there, but I will continue on unless you interrupt me. To talk briefly about roles and responsibilities. The clerk and recorder, boy, this individual, as is the case with elections all the time, bears the majority responsibility for compliance with all of this recall process. I'm sure they will consult a lot with your county attorney about this process too, but from beginning to end, your clerk and recorder and their office and their staff will potentially have a lot of extra work to do. As such, I think from your perspective as county managers, as county administrators, keeping that in mind and sort of checking in with that office, potentially investigating whether or not you can provide legal or additional staffing support as needed to those folks is something I would recommend doing. Of course, right, each county, each bucket of resources is finite, and each county is different. But if you can check in with that office and see if they need any additional support, even if it's sort of emotional and like, all right, we're with you kind of support as you take on this additional task. I think that's important to do. What to do, however, noting that this office and this particular elected person has a lot on their shoulders, what do you do if your clerk and recorder is the person subject to recall? That could happen. The statutes, fortunately, give us some guidance, which is that the BOCC, the county commissioners, shall immediately appoint another person to perform the clerk's duties. And I should have had noted on here additionally, to perform the clerk's duties related to recall. Okay, not carte blanche, not putting the clerk on paid administrative leave or something, like that. But the county commissioners are directed to, if it's the clerk and recorder who's subject to recall, to appoint someone immediately to perform the recall tasks that we just went through, all those statutory obligations and timeframes. Someone else is appointed by the county commissioners to perform those tasks while the clerk and recorder continues in office. What's on your plates during this process as the county administrator or the county manager? I think that, again, as mentioned, with kind of checking in with the clerk and recorder's office, I think continuing to manage the workplace, continuing to manage the organization as you do on a daily basis, but there is this potentially sort of disruptive process that's bubbling out there, and your leadership of the organization as a whole, I think, is important during this time, and understanding the needs of the clerk's office, recognizing that people beyond the clerk and recorder's office, in particular, let's say the department that is overseen or headed by an officer who's subject to recall. Let's say it is the sheriff, to use that as an example again. What do folks in your jail, what do the deputies, what do command staff level folks, how are those people dealing with having a leader, right, and the ultimate elected leader be the subject of the very public process of potentially being recalled? Recognizing that there are those dynamics in play that your workplace and those in it might be feeling some anxiety, and checking in and offering support in whatever way you can. Again, whether it's again acknowledgement that this is going on, and that the organization will get through it, and that you're available to people, I think is a good way to handle that. But managing the workplace, I think, goes a long way in terms of helping the people who are maybe not technically subject to the recall, but who will be impacted, helping those folks through the process by providing support to them. Finally, I note FCPA compliance, Fair Campaigns Practices Act compliance. As with any election, it's important for you to remember, check with your county attorney on this, right? What can employees say? What can you say as an employee of the organization? What can county funds be used on and not, in terms of the subject of a recall election, if indeed you end up having an election? The FCPA gives us guidance on those questions in this context, just like every other election context. So with the final topic I want to touch upon, and again, real briefly, I know we got a couple minutes, is kind of the postmortem of recall. If you recall election and you've gone through from the beginning, through the whole process of actually having one, and it's over, now what happens? After one recall petition and election, no further petition may be filed against the same officer during their term, unless signing petitioners equal 50% of the votes up from 25. So you don't get to go at it again, recall committee, without a higher threshold. In the case of a failed recall, the incumbent is eligible. Again, they have held on to their office. They're eligible for reimbursement from the general fund for qualified expenses that they've expended in opposition to the recall. Those are defined as money spent after the petition is deemed sufficient, campaign literature, advertising, maybe having a campaign headquarters, those kinds of things. Not, let's say, meals, right, while they're out on the road campaigning, and things like that, but truly the nitty-gritty sort of typical campaign effort expenses. Those can be reimbursed to an extent, because the statutes cap the reimbursement not to exceed 40 cents per eligible elector, or up to $10,000 in that event, whichever is greater, right? 40 cents per eligible elector, or $10,000. There's a whole process about how a detailed report of expenses is filed, which eventually goes to your county treasurer. But since we're running short on time, I will just mention that so you're aware of it. If the recall succeeds, right, so your incumbent is recalled from office, but nobody throws their hat into the ring to be nominated to fill the vacancy, then what? If it is a county commissioner vacancy that is created, that is filled by the statutory process that has several doors depending on the type of commissioner office. Either a vacancy committee or an election is held to fill that. In any other elective office, clerk and recorder, treasurer, coroner, any other vacancy in those kinds of office would be filled by the Board of County Commissioners until the next general election. As mentioned on the previous slide, county personnel, I think top to bottom, can experience the same sorts of post-election feelings, tasks, and adjustments as with a regular election. Some of your people may end up with a new boss, and the boss that they had gotten accustomed to is no longer there. So be cognizant of that. They may be experiencing that. And my final note, kind of tongue-in-cheek, but kind of not, and that's the question I'm sometimes asked, is recall contagious? do these happen in pairs or threes or sort of a lot? And I will say that, again, in my sort of, I think, kind of outsized experience in terms of the frequency of recall elections, it's my opinion that they're not really contagious. It is such a process, as we've just covered. There is so much that's involved, not only for our organization, right, the county organization, not only for the incumbent, but the recall committee as well. So much work and time and energy is expended. They're advocating for a ballot issue and waiting on election night much like the incumbent is. I have not seen rashes of recalls follow each other and be kind of clustered like that. I think there is some truth to some communities being more likely to engage in recall than others. But in terms of the actual process itself, sort of tending to be repeated because people see it play out, I have not seen that happen in my experience. But with that, let me take off my screen share. I realize that we're a few minutes after our projected deadline. And yet, let me escape out of that. I am more than happy to address any questions or take any comments. To those of you who do have the time to stick around, to those of you who don't, thank you for giving me some of your time and attention today. I think it's a very important topic. I think it's a super interesting topic, maybe you can tell. And it can be very impactful for a community. It's an interesting intersection of both law, I think, and the human experience and emotions and workplace issues and personnel issues, a lot of things going on with recall. And I'm happy to talk further with anybody who has anything else to say or ask. And if not, that's perfectly fine too. I would like to say, oops, let me check chat there. I'd like to thank Leslie and Sabina, Pueblo County Manager, and you, Leslie, who reached out to me initially to come and talk with you folks. I'd like to thank you for inviting me to come. I'd like to thank all of you with ACCA for your attention and time and opportunity to share with you what I think about recall. If after today, after this hour, you do have questions or comments, but in particular inquiries that, again, you didn't have time to submit, I'm absolutely happy to consider those and respond to those. If you send those to Carrie and Leslie, I'll let them know it's absolutely okay to reach out to me. I'd be happy to answer questions because I know I covered a lot. Hi, Gigi. And I probably spoke pretty quickly there, trying to get everything I wanted to communicate communicated. So I'm happy to answer any questions. And Gigi,
Thanks
you're
a lot,
welcome.
Carmen. As somebody who's unfortunately been present and or had recalls happen in my previous county, both successful and unsuccessful, I think the great reminder to us as managers is to make sure that our staffs know we're often pulled either by the folks wanting to recall or by the incumbent to come to their side and to give our staffs that understanding that there's this is not a place where you want to be as a staff member, pro or con, that you are apolitical, and that unfortunately, even if this person's your friend, not to get pulled into this because it can easily come with a lot of collateral damage.
Yep. Well said, Mike. It's again, like any other, I mean, not like any other, but in some ways like any other kind of election in that respect, or any other ballot issue in that respect. You may be asked and persuaded, or you may be solicited to take a certain stance. And I'll say, as a lawyer, you could do that on your own time, on your own dime. All of that is okay. As a county employee, on county time, with the county dollars, you absolutely should not do that.
And the public has a hard time believing that you did it on your own time and your own volition. So if they choose to go that way, I think they just need to understand that there can be a consequence to that.
Yep, for sure. All good reminders. And again, well said, Mike. I think these are tough processes, but we do get through them. Mike and I are living proof. You can survive a recall election. It's not fun for really anybody involved, but it is survivable and navigable. And again, thank you for having me. It was a real pleasure to speak with you, and absolutely reach out if I can ever answer any additional questions.
Thank you, Carmen.
Thank you, Carmen.
Great.
And I'm sorry, I just wanted to point out that there was a lot of information there, and this is being recorded, and we will put it up behind the member wall. They'll have to log in to access it. And if any of you are members of CCCMA but not ACCA, we can get you a copy of that recording.
Perfect. Thank you, Leslie.